Do not ask me. I'm asking you. Yes or no only. That's a very categorical
Same
question.
with Justice Baldos. I vote
not
for
for you
the
to
in favor of
judge,
the
Panero.
negative
You are
because it
under
is very
oath. This
clearly
is actually
provided
related to
under
your-
such a law that a 16-year-old can
the age
give
of
already
sexual
consent in sexual
I am
activity,
inclined to think that
the
it is
partner
the
must
age
not
of
be
16
3 years
is the
old.
age of sexual consent, and therefore I give it to the negative side.
Categorically stated there that the age of sexual consent is 16. The official statement of the Senate will bind me as a judge. So, there being no other sources to draw an answer from. No? That the age of consent is the
Ito po si
16.
Fiscal EJ at your service.
Magandang araw po sa lahat, si Fiscal EJ po ito. Tanong, is truth an absolute defense in cyberlibel? Meron kasing mga nagsasabi at mga naniniwala na ang truth daw is an absolute defense in cyberlibel. Mali po ang paniniwalang yan. Bakit ko nasabing mali? Tingnan po natin kung ano ang nakasaad sa ating batas. I'm talking about Article 361 of the Revised Penal Code. Ito po ang nakalagay sa Article 361. Article 361, Proof of the Truth. In every criminal prosecution for libel, the truth may be given in evidence to the court, and if it appears that the matter charged as libelous is true, and moreover, that it was published with good motives and for justifiable ends, the defendants shall be acquitted. Proof of the truth of an imputation of an act or omission not constituting a crime shall not be admitted unless the imputation shall have been made against government employees with respect to facts related to the discharge of their official duties. In such cases, if the defendant proves the truth of the imputation made by him, he shall be acquitted. At first glance, especially kung babasahin mo lang ang first paragraph, it would seem that truth may well indeed be an absolute defense. But look closely at the second paragraph of Article 361. Ano ba ang nakalagay sa second paragraph? Ang second paragraph po ay ang paragraph na nagbibigay ng qualification or limitation sa scope ng first paragraph. Ibig sabihin, hindi pala absolute defense ang truth. Magiging defense lang ang truth sa cyberlibel under any of two instances. Under the first instance, proof of the truth can be used as a defense when the defamatory statement is an imputation of a crime, regardless of whether the person libeled is a private individual, public officer, or a public figure. For example, si Pedro, isang sikat na vlogger, umiiyak sa kanyang YouTube channel dahil gusto daw siyang ipapatay ni Juan na isang congressman. Nag-file ngayon ng kasong cyberlibel si Congressman Juan dahil ang paratang ni Pedro na gusto siyang ipapatay ni Congressman Juan ay isang imputation of a crime. The crime of grave threats under Article 282 of the Revised Penal Code. And you already know na pag imputation of a crime, it is per se defamatory. Pwede bang magbigay ng proof si Pedro na talagang gusto siyang ipapatay ni Congressman Juan? Yes. But it's not enough na basta na lang sasabihin ni Pedro sa fiscal o sa judge na he is telling the truth. Merely having good intentions is not proof. Kaya nga, proof of the truth ang tawag. Pedro, therefore, must present evidence that Juan really uttered words to the effect that he threatened to kill Pedro. Kung nag-bad joke o nag-death wish lang pala si Congressman Juan, magiging liable for cyberlibel si Pedro dahil wala naman talagang sinabi si Congressman Juan na ipapapatay siya. Now, what if nakapagbigay ng proof si Pedro na gusto siyang ipapatay ni Juan? Maaabsuelto ba si Pedro? Proof of the truth alone is not a defense. Hindi po enough ang proof of the truth. Aside from proof of the truth, kailangan pa pong i-prove ni Pedro na he published the defamatory imputation with good motives and for justifiable ends. For example, ipagpalagay na natin na talagang nag-death threat si Congressman Juan. Nagpadala ng text message si Juan kay Pedro kung saan sinabi niya sa text, "Pag hindi ka tumigil sa pag-atake sa akin sa channel mo, ipapatumba kita para tumahimik ka na." Pwede bang ipagbigay alam ni Pedro sa publiko ang banta sa buhay niya? Like for example, ipakita niya sa kanyang mga tagapakinig ang text message na natanggap niya mula kay Juan? Yes po. In such case, merong good motive and justifiable end na ibalita ni Pedro sa publiko ang death threat na natanggap niya mula kay Juan para maprotektahan niya ang kanyang sarili. But aside from merely publishing it in social media, Pedro must also have the threat incident blattered in the police station, and if warranted, a criminal complaint for grave threat should be filed against Congressman Juan in the proper forum. Ano naman ang mangyayari pag hindi nakapagbigay ng proof si Pedro dahil guni-guni lang pala niya ang lahat? Mako-convict po si Pedro dahil gaya ng sabi ko, an imputation of a crime is libelous or defamatory per se. Let us now go through the second instance where truth can be a defense. Under this second instance po, truth can be a defense when the defamatory imputation is against a public official, provided such imputation is with respect to facts related to the discharge of his official duties. Now, under this second instance, ito po ang mga requisites para pwedeng gawing depensa ang truth. First requisite, the person libeled is a public officer. And second requisite, the defamatory imputation is with respect to facts related to the discharge of the public officer's duties. In other words, even if the defamatory imputation is not an imputation of a crime, for as long as such imputation is with respect to facts related to the discharge of a public officer's official duties, the accused may prove the truth thereof. Conversely, pag hindi konektado sa trabaho ng isang public official ang nasabing defamatory imputation, kahit na totoo pa ang paratang, hindi po pwedeng maging defense ang truth. For example, pinaparatangan ni Pedro sa social media na si Congressman Juan ay babaero at pabayang ama. Ito po ay isang paratang na walang kinalaman sa trabaho niya bilang congressman. Kahit na may katotohanan pa ang paratang ni Pedro, hindi niya po ito pwedeng gawing depensa kung sakasakaling sampahan siya ng kasong cyberlibel ni Congressman Juan. Take note po that in both instances that I have mentioned, proof of the truth is not enough. Kaya nga ang sabi ko sa simula pa lang, truth is not an absolute defense. Why? Because the accused must also prove that the matter charged as libelous was published with good motives and for justifiable ends. So ano ba ang mga instances where proof of the truth is not a defense? Proof of the truth is not a defense whenever the imputation is an imputation of a vice, an imputation of a defect, or an imputation of an act, omission, condition, status, or circumstance that will tend to cause the dishonor, discredit, or contempt of a natural or juridical person, or to blacken the memory of one who is dead. So for example, pinaparatangan ni Pedro si Juan sa social media na isa siyang drug addict. Now, kahit na nag-positive pa sa drug test si Juan, hindi po ito pwedeng gawing depensa ni Pedro kung sakasakaling sasampahan siya ng cyberlibel ni Juan. Truth is not a defense when the defamatory imputation is an imputation of a vice. Why? Because imputation of a vice, a defect, etc. is not among the instances where proof of the truth can be used as a defense. So, wag po tayong maniniwala sa pinagsasabi ng iba na truth is an absolute defense. Ipagbase po natin ang ating kaalaman sa batas because such a claim is utterly wrong and devoid of legal basis. Maraming salamat po.